Good morning, Sat Sri Akal, Adab, Namaskar. My fellow friends, in this continuation of the series, I am coming up with another video. This is again on the resumption cases, or even if not resumption, possession, eviction, injunction, or whatever. This is an extensive case called Manalal Agarwal versus Union of India, 1963. Okay, this case actually was filed Union of India, Bhai Golchar Jahangir Baksh, but finally Manalal Agarwal. At that time in 1963, he was about 60 years of age, living in Rajendra Prasad Marg, Adalat Road, Aurangabad. And he filed a case against some defendants. And it was Union of India, Defence DO, CO, and some possession holders, Munna Swami, Durga Swami, Harnam Singh. This is how it is. So what is the suit? Suit number 15 of 1963. I would read these briefs. This entire case is to be read and this may cover in about 2 or 3 videos because it went up till Supreme Court. What is the case? What was the major application which spoke of what? So we'll talk of the claims. First, in his claim, he was talking of the Constitution, Article 226, 19, 31 and 12, the executive actions. And somehow he mentioned some court judgments. Then he came down to the Cantonment Act, Section 3, and then he said that there could be no presumption of bringing in lands within these cantonments, could be the benchmark of all lands belong to government, and the Evidence Act must come forward under these Bombay regulations of 1826 and 1875. Again, he brought in the Evidence Act, Section 35 and 144, that entries in the registers of the government maintained documents are no presumption in law. Right? Fine. Bombay Land Revenue Code he brought in 1879, Section 37, scope of private properties within the cantonments. And then cases were referred in this case. Now, coming down, what was the suit? It was regarding possession of land, survey number 20, measuring approximately 7 acres, 25 guntas. The plaintiff claims to be the owner of such and such survey number, Cantonment Board, Aurangabad, well as Union of India, known as Suraj Kundwala, to the extent of so and so. Land revenue which he was paying at that time was 13.50 paisa, situated at Karanpura within the limits of Aurangabad. And for, now the second part what this owner is asking for is he is asking for means profit of rupees 1500 for the last 3 years, 1963 and back, and future means profit at the rate of rupees 500 per year. Now what are the averments made? Now the averments are very clear that this survey number 7.824 acre land which was paying revenue on its east, it had an octroi naka of city Aurangabad, the land belonging to Barkatullah, to the west Kham river and a bridge, to the north Cantonment Garden, a line of trees which was originally owned by some Kalababi, wife of Ratan Singh Rajput residing in Karanpura. Hira Lal, some father plaintiff, and so 19 registered. And this is where this property changed hands in 1941. The sale was subjected to resumption of original mortgage of land with Jagat Singh and son of Sukha Singh, the father of defendant number 4. Hira Lal filed a suit for redemption of mortgage against so and so and the repayment of rupees 400. Paying this amount, Hira Lal obtained possession of the suit land from Jagta Singh. Okay. The entire area of Karanpura, Padampura, which was formed a part of Aurangabad, originally belonged to His Highness Maharaja of Bikaner, along with the king some persons had come to this area and they were donated various lands from the inhabitants and cultivation, and out of them was Ajaib Singh, son of Vitho Bhai Singh, who was the pattedar of survey number 20. He was in occupation and possession of this land, paying a revenue to the then Bikaner estate. After Ajaib Singh, son Gopal Singh, after him his wife Kalabai were in possession, the owner of the land and paying revenue for the past 100 years. Now 1963, please, this goes back to 1863. The right of the possession has been perfected due to the prescription as owners. The plaintiff purchased this from Kalabai, this property. Now there was a police action in 1948, Hyderabad state. So under section so and so cases were filed and it kept going on. I'm not getting into those nitty-gritties. What happened later? The police entered into the property. A suit was filed, number 122 of 1 of 1955. Fathers got it amended. The relief for possession was discussed, and the compliance of notice was made during the pendency of the suit. The objections were raised by defendant number 1. The military state officer was not joined and made party to the suit. Well, in 1955, the degree was passed, and accordingly, survey number in dispute was given exclusively to the share of the plaintiff. So the suit had already gone into him. So why A was a party or not is not the question. You need to be a party only when you want. Now, Exhibit 16 filed a written statement, that is defendant number 4. Exhibit 66, a written statement by defendant number 1. Now, here the defendant number 1 is saying in the year 1903, the government acquired 4 Bikaner villages, Karanpura, Padampura, Kisharan Singhpura and Kokanwadi, adjoining 918 acres, 39 guntas, an estimated cost of 37,000 from Aurangabad cantonment limits, and accordingly possession thereof was taken. A telegram number 70 of 1904, the fact of taking possession was communicated to the Adjutant General Secunderabad by officer commanding Aurangabad. This is an interesting happening. You know, Aurangabad and Secunderabad are 2 cantonments where a foreign notification has been done for the implementation of CLA rules. This case will open the eyes of a lot of bungalow owners staying in Aurangabad as well as in Secunderabad. I hope the president of Secunderabad, Mr. Agarwal, and what is his name, the secretary of the new association, I'm forgetting, they must watch this. Now, Karanpura comprising in the General Land Register as survey number 71 and 72, and the new survey number given was 74 and 75, measuring 17.1994 acres according to the GLR of 1934. So this is the same GLR which is made under the CLA rules of 1925. And 20.49 acres as per the GLR, respectively known as Health Camp and Cantonment Gardens. 2 GLRs, speaking different. Now what do we need to prove? We just need to counter the GLR here. Now, well, this is how the land is given to one Punna Swami by the President of India on lease lawfully, and such the plaintiff claim for possession and means profit also cannot be entertained. The Union of India is a necessary party and vests in the President of India, and so and so. So originally these statements are coming, Exhibit 10.1, an amendment of the suit of 17 acres, 0.7 acres. The originally what was the claim being asked for? Well, you have to see, was somewhere around 7 acres, 24 guntas. Now it has become, instead of 17 acres, it has become 7 acres. Where have those 10 acres gone? God knows. So these amendments were happening. Now what have moved further on? issues were made. There were some 15 issues made. This is very important. Does the plaintiff prove that the title of Kalavati or a husband Ratan Singh was perfected by prescription as is contended in para 1A of the amended plaint? Does the plaintiff prove his title over the sued land? These are issue number 1, subpara 1 and 1, 2. Third issue. Does the plaintiff prove his possession with 12 years next before the institution of this? Does the defendant prove the suit land was acquired by Government of India, leased to Ratan Singh for cultivation on an annual rent of so and so? Is plaintiff entitled to receive possession? I am not reading the ones in ATC and all these notices. So these are the major parts. Now what happened in ownership? Yes, Manalal could prove. Yes, the plaintiff proved his title. Yes, no, the department could not prove that they acquired these lands in 1903 or 4. So there were so many things which happened in this case. Reasonings were given. This whole case is with me. And reading this case would be an amazing thing for people in Aurangabad. I'm purposely bringing up these cases now. We don't commute, we don't talk, we are sitting in our own coffers. Now listen to this. This suit under section 5 of the cantonment. What does section 5 of the Cantonment Act 1900 or section 4 of the Cantonment Act say? You can bring in any land in the cantonment, you can take out any land. This is called delimitation, which is now happening, called accession. Such area up become the subject and others belong to the cantonment from time being enforce the Cantonment Act. The Cantonment Act on the suit land from time here in 1903 or the land from Aurangabad cantonment. Where was its applicability then? Whether it was the 1898 Cantonment Act or what? So these are the questions which need to be. As far as Sikandrabad and Aurangabad cantonment property is concerned, there was a Sikandrabad and Aurangabad cantonment properties rules in 1926. While a foreign and political department notification number 261/1 dated 9th June 1926 under rule 3 of these rules, a register of movable immovable properties which vest in and belong to the cantonment authority was to be maintained by the cantonment authority in the form prescribed in Rule 70 and 71 of the Sikandrabad and Aurangabad Cantonment Accounts Code 1926, and all additions and alterations holding the cantonment authority was to be recorded therein. So this is where this judgment and this entire case is very important. The main contentions, they picked up, a government pleader has relied upon on ILR 1936 Bombay 1, wherein it is held the properties in Pune is government property. AI 19 Bombay Cantonment Act, wherein it is held that the lands in Pune cannot be an assumption. So these all are being discussed from Rule 4, whereas Class C is meant for land vested in Cantonment Board. Definitions of lands have been given. 4B1, land over which neither the government nor the Cantonment Board possess any rights. For the reference, it is clear that there are private properties in the cantonment area and no assumption. It can be stressed that following the property in the cantonment area, it vests alone in the Cantonment Board. So these kind of conclusions were coming on. Now, who was in the possession? He again says, since the period of the Bikaner ruler from 1641, standing in possession, the prescriptive title is assessed by the plaintiff. So the Bikaner estate since 1641 was in possession of this Aurangabad estate. What is the government or what is the department? So Manalal Agarwal was trying to hit into that word old grant. But since during those 1963 and prior these records, availabilities were very weak, He was trying to get it from this cessation of fact of possession of the plaintiff prior to dispossession becomes admitted. Apart from the pleading, there is some other evidence showing that the plaintiff's father was also in possession after the sale of the land by Kalabai to the plaintiff's father. So all along Manalal ji was in possession of the property since he purchased from Kalabai. Exhibit 242 and 243 exhibit clearly shows the receipt of 9th June 1900 respect of land revenue. This is the most unbelievable document which is in hand of Manalal Agarwal. Exhibit 243 for the year 1907-1908 by Kondi Ram paid to the Kattha of Bikaner village is a copy of letter of 1939 from the exhibit 42. In this letter, Kondiram is informed about the sale of land serial number 2324 in Karanpura, serial number so and so at Binwadi, and to make necessary entries in the register and to recover land revenue from the concerned parties. Why can't we people, somebody in Aurangabad or anywhere in Pune can actually get down and lay hand on these exhibits officially? I have these documents. But these are all sent through a bungalow owner. Under Rule 3 and under the caption needs for arrangements to ensure with the rights of government and cantonment lands are not adversely affected by incorrect entries in the civil land record, some instructions are given according to the MEO. Where are these instructions? Where are these manuals that the Jamabandis and the Gurdwaris were being changed? So friends, till 1949 or 39, these were agriculture lands, land revenue was being paid and no one had the records. So we have to, this judgment and this order is very important. We will continue with this. This is in continuation to my earlier part which I had missed. We are talking of a case of Manalal Agarwal. This is of Aurangabad related to 7 acres and 24 guntas which was given a survey number 20. Now as I just said in the earlier part that his exhibit 243 which is a receipt of June 1908 which becomes a land revenue receipt is very important. Into the same continuation, a revenue register of 1916-17 up to 1948-49 had been produced. Now this land revenue register is very important. I will request anybody from Aurangabad to fish into these records and of 1963 take all the exhibits attested copies. It tried to suggest that Shiv Singh was not given any authority to collect land revenue and this suggestion is denied. Now see what the department is playing. It is playing the dirty role. For the person Kondirama, the authority is accepted and there appears to be some gap between the period after the death of Kondirama until the land revenue was started to be collected by the cantonments. We don't need to get into all this, who's doing it, who's not doing it. This is a land revenue register maintained. The witness has stated that from 1940 to 50, the cantonment started collecting the land revenue. This fact can be supported from Exhibit 191, which is a land revenue receipt produced by the plaintiff and issued by the cantonment executive officer dated 12/3/1950 for the land survey number 20 and 26 for the year 1949 and 50 to deny the authority. Shiv Singh prior to 1940-50 is collecting the land revenue as it has been said. So these aspects become very important, and why am I detailing this judgment of the lower court? It is so important for our future cases. Now From this it is clear that Shiv Singh was also collecting land revenue of lands within the cantonment area, and particular even for the suit land. The plaintiff purchased the property in 1941 and took possession of the suit land from Jagat Singh in the month of 1942. There is a copy of judgment which allowed to produce to plaintiff as a secondary evidence at Exhibit 275. This is of the case suit number 19 of 1941 against Jagat Singh, filed by the plaintiff, where a mortgage redemption was done because Jagat Singh had to hand over the property. Now, the certain receipts of land revenue which were exhibited as 213, Exhibit 188, Exhibit 189, and then Exhibit 190, Exhibit 267, 214, 215, Exhibit 191. All these receipts are referring to survey number 20. Exhibit 236 is the General Land Revenue Register, wherein GLR survey number 7-72 are referred, and is alleged by the defendant that these two GLR numbers are for the old survey number 20. There is one more copy of GLR register at Exhibit 246 and at Exhibit 247 for the GLR survey number 74 and 75, which are stated in column 5 as the part of survey number 20. In these two GLRs, it's very important, the name of landlord is shown as central government. Now, there is no record on behalf of the defendant to identify these two GLR numbers 7172 and 7475 with survey number 20. Though Exhibit 248, an extract of map from the Survey of India, is produced, it refers to survey number 20, and DW number 1, this is the defendant, Union of India, has admitted that the original map is printed and the word cantonment garden and quarantine huts is written on the map in ink. That means that it is not a part of the original map prepared in the year 1917-18. How far the wording about garden and hut is concerned, there is no map produced by the defendant showing these GLR survey numbers with identify survey number 20 particularly. Wake up. If we go through Exhibit 246, 247, serial number 74, 75, as stated in column 5, it appears that the entire entry of survey number 20 originally was 17 acres and 24 guntas, and if we add the acreage of survey number 20, 74 and 75, it exceeds to 20 acres. That means some more part is covered other than survey number 20 in these two serial number 74 and 75 as per the GLR of 1952-53. The witness DW1 has stated that the GLR is prepared in the year 1952-53. So what are we left with? Guys, when I got this judgment, and I had already lost in the High Court in my case in 2011. After the convention in 2012, I happened to visit Aurangabad, and Mr. Karan Kakas actually shared this judgment with me. And finally, he later on shared the entire paperbook of this. His hard work, to his knowledge and ability, is extensively amazing. We must thank Mr. Karan Kakas for this. Now, pointing out to these various happenings, there are the copy of letter of an Exhibit 269, the history of property coming from cantonments. Aurangabad is stated from here. it appears that the original 919 acres of land was acquired by Government of India in February 1904, comprising of these 1, 2, 3, 4 villages, ex-Bikaner villages, at the cost of sum amounting 27,000 rupees. Out of an average 5 acres were retained by the military authority, and the remaining land was handed over to the His Highness Nizam government in the year 1930. Again, it is clarified that out of 523 and 1044 acres, 287 and 787 acres respectively are in active occupation of the troops, from where the very beginning, and the remaining acres were not required for immediate occupation of the army, and the cultivators therefore were allowed to remain in possession on payment of land revenue as were levied. Do we need anything more? It is only, if you have knowledge, you can extract all this. Manalal ji did read a lot of books, did have a lot of evidence in his hand. 1963 is not small, there is a case even in 1865, but to this magnitude. Exhibit 272 has expressed the opinion of the letter dated 1955. The copy of this is attached as Exhibit 272. Has expressed its opinion that under Section 13 of the Land Acquisition Act, no actual possession was taken from these persons. In actual possession, the acquisition was not complete, and the occasion of the lands by the riats were as ex-pattidars or cultivators in an encumbrance, and the long possession and enjoyment of proprietary rights, their recognition as owners or permanent lessees cannot be resisted, and that clarified the position of regarding the status. So we are referring to so many things. Now, the advocate of the defendant refers to Rule 8, Clause 2 of the Cantonment CLA rules and submitted. The land being within the cantonment, west with the government. Now see, again this theory and the story is going that all lands within the cantonment boundary pillars west with the government. It's amazing. All lands in the cantonment which is vested in the crown except land B2, which is permanently occupied or used by provincial governments, whether applied, suitable, and so on and so. Under Section 5 of the Cantonment Act, any local area is included in the cantonment. Such area shall thereupon be subject to the Act throughout the cantonment and all its notifications. The class A, B are for the lands vested in the crown. C is meant for the land which is vested in the board under Section 108, and so on. In class F of Section 108, a land or property transferred to the board by the central government, state government, or gift otherwise. There is so many things being discussed in this case, and we really need to work hard on this. Finally, the discussions reach to a pinnacle where the word west and vestment is discussed. The word phrase west is interpreted, it is held has not got a fixed connection, meaning in all cases that the property is owned by person or authority in whom it vests. It may vest in title, or it may vest in possession, or it may vest in limited sense, as indicated in the context in which it may be particular. Taking this ratio from the citation, it can be said that only the management of such land in continuous possession of the person was vested in the cantonment and not the proprietary rights. So the vestment has been challenged here. It has been stated on behalf of the defendant that the person in occupation were given the lands on rent now. See, now they are saying this land which was acquired by the government is being given to them on rent. You acquire something and then you rent it out something. Except the pleading, there is no other document to show that this property was actually leased or rented. Even if the documents refer to the payment of rent, then is not sufficient for a relation for a lessor and a lessee. are required to be established. Where is it written? Again, a judgment of Supreme Court, AIR 1962 is quoted. If we take the word rent, it connotes the transfer of lease. Admittedly, there is no lease agreement in this case. So this classification, exhibits, basically the Cantonment Board and the army were trying to fix in their proprietary rights in this property. And for that reason, they were playing this dirty game. And that kept going on. Further on, the classification of B4 land, the cantonment land administration, the cantonment required to maintain a register. In the earlier register, the cantonment which has produced on behalf of the defendant and stated to be consolidated list of immovable properties shown as an ordinary privately owned land. So all the while the cantonment had not manifested any proprietary rights on the suit land. These things are becoming so important in this case, and he is now this exhibit 215, the perpetuity from the Bikaner ruler, and is a revenue book regarding cultivation of lands of these 4 villages in which one of this land comes. This revenue book is stating belonging to Ratna Singh Gopal Singh. The receipt appears to have given by Ajay Singh way back in 1986. This is a land had been under the management of government with the proprietary rights in the cantonment. Then the cultivation of the land's lease agreement had been there and the entry to that effect had been given. So here you have a case where leases are there. So exhibit 260 again speaks of Ratna Singh and his proprietary rightship. So to give a prospective title to the plaintiff at the most, that by the acquisition of this village, the cantonment through the British government had acquired their respective rights for certain lands, the rights of the management only. For vesting the management, the land, like the suit land, can be illustrated. So the issue number 1 is given finding in the affirmative. So who is the owner? One has to understand. It is not the government. Issue number 9, the suit is filed within 12 years from the disposition as required under Article 142 of the Indian Limitation Act. Issue number 5, prior to the amendment of the plaint, has claimed that land to the extent of 17 acres and has amended it to 7 acres. That is also justified. So with these kind of justification, the issue number to the plaintiff is entitled to recover of possession and he has claimed every right and part of the means profit prior and in future. But this will be given under CPC Order 20, Rule 20. So gradually this case goes down that the rights of the plaintiff have been upheld. Now, does the defendant plaintiff prove the title? Now, this is the finding which is the most important finding in this. Ki after this exhibit 260. So, friends, please wake up. We can win all our cases. This is an example of my statements given. Please find your land records. If you do not find your land record, if you do not dig into your records, the army and the department will keep saying that either we skeeted to them, either they won, British won us through war, or we acquired lands. The Land Acquisition Act first came in 1950, then it was upgraded in 1870, and then finally in 1894. So please wake up. Thank you. And this series of Manalal Agarwal will continue in my second video, which will be of his other cases filed by the Union of India in Session Courts, High Court, and then finally Supreme Court. Thank you. Good day.